Good morning. The Subcommittee of Water Resources and Environment of T&I will come to order. A little bit of housekeeping. First, I ask unanimous consent that the hearing record be kept open for 30 days after this hearing in order to accept other submissions of written testimony for the hearing record. Is there any objections? Hearing none, so ordered. I also ask unanimous consent. No, we don't need that. Don't need, okay. Take care of that. Today we have one panel. Welcome witnesses. I'll start off here with my opening statement. Again, I'd like to welcome everybody to the hearing today. We are here meeting to examine the EPA's expanded interpretation of its permit veto authority under the Clean Water Act. Today, we will hear from multiple stakeholders on the potential economic and job creation impacts of the EPA's new interpretation of their veto authority under the Clean Water Act. The Army Corps of Engineers has the lead responsibility for implementing the Wetlands Dredge and Fill Permitting Program under Section 404 of the Clean Water Act. Under the Wetlands Permitting Program, the Corps is responsible for receiving and reviewing Section 404 permit applications and issuing wetland permits. Section 404 assigns the EPA a limited review role in regard to Section 404 permits. EPA may comment on Section 404 permit applications during an interagency review period for each permit. And EPA also has the limited authority under Section 404C to prevent the Corps from issuing a permit to authorize a particular disposal site or to restrict the terms of the permit if the EPA determines that the permit would result in certain unacceptable environmental effects. Consistent with this process, in 2007, the Corps issued a Section 404 permit for the Spruce No. 1 mine project in West Virginia. Prior to the issuance of the permit, the project applicant conducted an extensive 10-year environmental review in which EPA fully participated and agreed to all of the terms and conditions included in the authorized permit. Subsequently, the mine operated pursuant to and full compliance with Section 404 authorization and made substantial investments in the project in reliance on the permit. However, in 2009, the EPA unilaterally changed the rules of the game after the fact and took steps to revoke parts of the Spruce project issued permit even though they were in full compliance with the conditions of the permit. More than 3 years after the permit's issuance, EPA finalized the permit revocation in early 2011, halting development of the mine, jeopardizing jobs and the substantial investments, and injected uncertainty into any industry impacted by Section 404 permitting. After the permit holder challenged EPA's permit revocation action in the federal courts, the U.S. Supreme Court has decided not to review the 2013 appeals court decision that the EPA did not exceed its power when stripped the Spruce mine of its 404 permit. Revoking a permit after such has been issued and when no violations of the permit, I want to make that key, no violations of the permit have occurred is unsettling. It is an arbitrary and irresponsible way for government to act. The EPA has not only asserted itself after a permit has been issued, it has recently been preempting potential applicants. A recent example of the EPA perhaps illegally exercising its veto authority before someone even applies for a 4 permit is in the Pebble Mine, Bristol Bay, Alaska project. In this case, without ever receiving an application describing a proposed action, the EPA has declared that no permit, regardless of conditions and potential public benefits, can ever be issued in that designated area. I consider this regulatory overreach to be a fundamental property rights issue. With this new and broad interpretation of its powers, EPA is setting itself up as the ultimate manager of land use and economic development in the nation. This is an example of government that thinks it has no limitations on its power. The EPA's newly expanded interpretation has the possibility of becoming a very dangerous precedent by opening the door for revoking not just 404 permits, but perhaps other permits as well. This new action by EPA will affect both public and private development and raises the question, what does it really mean to get a permit? What does it mean to get a final decision from the federal government? If an agency is given the right to unilaterally revoke an already issued permit, then nothing can ever be considered final. The issuance of a federal permit should come with the certainty that the activity can go forward unencumbered but within the bounds of the permit, particularly those activities in private lands. This no longer seems to be the case, and it is going to have a stifling effect on not just mining operations in Appalachia, but on economic development nationwide. I look forward to the testimony from our witnesses today, and it's time I'll yield to Mr. Bishop for a statement of comments he may have.
Thank you very much, Mr. Chairman. I appreciate you holding this hearing, and I appreciate you yielding to me. I recognize that there's a difference of opinion among members of this panel on the activities of executive branch to protect public health and the environment. However, I'm troubled by the tone taken by this Congress in carrying out its oversight activities of the current administration. Too often these days, we have let the rhetoric surrounding controversial issues overtake the reality. And this seems especially true when it comes to talking about actions of the Corps of Engineers and the Environmental Protection Agency. Today's hearing is an example of this. The title of this hearing talks about the EPA's expanded interpretation of its Clean Water Act authority, as though this agency is creating new authority by its actions where none previously existed. Our former senator from the state of New York, Daniel Patrick Moynihan, once said, "Everyone is entitled to his own opinions, but not his own facts." And so as we begin this hearing, it's important that we all have the same set of facts from which to work. Here are the facts. Fact number one, Congress enacted the Clean Water Act in 1972 and provided the Corps and the EPA complementary roles in the implementation of the federal Section 404 permit authority over discharges of dredged or fill material at specific sites in waters of the United States, including the adoption of the EPA's 404C oversight responsibility. Fact number two, since enactment of the Clean Water Act, the Corps of Engineers has processed, on average, 60,000 Section 404 permit applications per year, resulting in over 2.5 million approved permits since 1972. During that same period of time, the Environmental Protection Agency has exercised its Section 404C authority a total of 13 times. 13 times in 2.5 million permit applications. Fact number three, of the 13 actions taken by the EPA under Section 404C since 1972, 12 were under Republican administrations, and only one, the one that we're discussing this morning, was under a Democratic administration. I will note that 8 of the 12 under Republican administrations were during the presidency of Ronald Reagan. Fact number four, of the 13 times EPA has previously exercised its 404C authority, 3 of these 404C actions were taken after a Corps of Engineer permit was already issued, 2 under Republican administrations and 1 under a Democratic administration. An additional 2 404C actions were taken in the time period before a Clean Water Act permit was issued by the Corps, both under a Republican administration. Fact number 5. One of the projects that was blocked by a 404C action of a Republican administration was finally resolved and approved by this current administration. So as history has shown, the Environmental Protection Agency of both Republican and Democratic administrations has used its congressionally authorized oversight authority over the Section 404 program in a limited and relatively consistent manner. To characterize the agency's recent actions related to Section 404C as a, quote, expanded interpretation, close quote, is simply not supported by the facts or the historical record. Now, it's fair for members to have a difference of opinion on how the Corps and the EPA have carried out their Clean Water Act responsibilities. However, when we use that difference of opinion to mischaracterize or worse, to demonize the intentions of these agencies, I believe we fail to uphold our larger congressional responsibilities. In my view, the EPA seems to have exercised its 404C authority since 1972 with restraint, acting only when the activities in question would have had an unacceptable adverse effect on the local environment, the very test that Congress established for the agencies back in 1972. While I recognize that those who may have been affected by these actions may have a different view, I believe that these groups will have a difficult time in arguing that the federal agencies have abused or expanded this authority over the years. I thank all of the witnesses for being here today. I look forward to your testimony. I yield back. Thank you.
Other members may submit written testimony for the record. Today, I welcome the witnesses. Our first witness is Mr. William Kovacs. He's Vice President of Environment, Technology, and Regulatory Affairs at the U.S. Chamber of Commerce. And then we have Mr. Harold Quinn, Jr. He's President and CEO of the National Mining Association. Mr. Nick Ivanoff, Senior Vice Chairman of the American Road and Transportation Builders Association. Ms. Leah Pilconus, good, thank you. Senior Environmental Advisor Associate from the Associated General Contractors of America. Mr. Richard Falk, Senior Director, Energy and Environment, George Mason University School of Law, and Patrick Parenteau, Professor of Law at the Vermont Law School. Welcome all, and we'll start off with Mr. Kovacs. Floor is yours.
Thank you, Chairman Gibbs and Ranking Member Bishop, for inviting me here to discuss EPA's expanded interpretation of the permit veto authority under Section 404 of the Clean Water Act. I do recognize—
Mr. Kovacs, can you pull your microphone a little closer?
Oh, sure.
Is it on?
Yes.
Okay.
While I do recognize that EPA's permit authority under Section 404C has been upheld by the D.C. Circuit, I'd like to focus on the practical implications of EPA's expanded new policy by discussing first the real-world impacts of EPA's use of a retroactive veto policy authority, and second, the problems that arise when an agency, such as an EPA, but there are others, stretches its authority under broadly written statutes enacted decades ago, many of which have not been formally reauthorized by Congress in decades. In the practical world, securing a permit, and I think this is our biggest problem with the retroactive veto, is a multi-year effort involving complex studies, engineering reports, compliance with over 30,000 pages of regulations covering air, water, waste, endangered species, and environmental impact statements. When a permit is granted, the developer has complied with literally every regulatory detail. The developer goes through this torturous process to develop a significant project with the expectation that the project will add economic value to the community, create jobs, and increase shareholder value. The developer enters the permitting process believing that once it proves it can meet every condition imposed by the government, that it will hold the permit for a specific number of years to both complete and operate the project. EPA's retroactive veto means that a permit no longer is granted for a specific period of time. Rather, a permit has value only as long as the administrator believes it should not be revoked. Under EPA's new policy, a developer, in effect, only applies for a contingent permit, one that might be revoked whenever the administrator desires. And I raise this in the context of the retroactive authority is completely unnecessary in this environment. First of all, should the developer violate any condition of the permit, EPA has massive administrative, civil, and criminal enforcement authority, emergency powers, injunctive relief, and it can even revoke the state's authority to retain full jurisdiction over the project. So a retroactive permit authority creates such great uncertainty in the permitting process that developers will be extremely cautious before risking millions of dollars when needed to apply for a permit that they think can be revoked. And I say that because it's millions of dollars to get one of these permits. And while the D.C. Circuit's decision invoked a coal mine, and that's a very controversial issue, the fact is that the retroactive permit authority can be used in any 404 permit, including ports, pipelines, waterways, highways, airports, housing authorities, industrial facilities, and even big box stores. So we're moving into a path that might be much more disruptive than the political controversy over a coal mine. But EPA's retroactive permit authority is only one of the many ways in which the agency is literally unilaterally expanding its regulatory authorities. The claim of retroactive authority is merely the latest. In the case of Pebble Mine, which the chairman mentioned in Alaska, the developer spent over $1.5 billion, and it has not even yet been able to apply for a permit. In this situation, the activist petitioned EPA requesting that the permit be preemptively denied before even Pebble could apply for it. To appease the activists, EPA undertook a watershed assessment using outdated models and operations of a mine. While EPA has not yet preemptively prohibited the permit application, it has formally started the process to prohibit it. So we have a combination right now of EPA asserting a retroactive authority on a permit, a prospective authority on a permit, and when EPA moves forward with its waters of the U.S. and this greatly expanded area that they're going to have 404 jurisdiction over, it literally places most of the landmass that's near water in some kind of restriction that they don't have now. Couple these powers with EPA's other powers under other statutes, and then add into that Fish and Wildlife's efforts in expanding the habitat for endangered species, and the result is the government is developing policies that are built that will actually regulate most of the land in the United States. This type of regulatory structure is literally shutting down our ability to build infrastructure or large industrial projects anywhere. This is serious, and the nation will not begin to grow and create jobs until we can start building again. And I want to finish with the fact that several years ago we did a project called Project No Project, and we just looked at the number of facilities trying to get permits in March of 2010, and there were 351 private facilities that wanted to put in almost $600 billion worth of investment, and they couldn't get permits. And the permitting process is probably one of the most important things Congress can look at. Thank you.
Thank you. Mr. Quinn, welcome.
Good morning. Thank you, Mr. Chairman, Ranking Member Bishop, and members of the subcommittee. Thank you for the invitation to appear today and testify. And we appreciate your efforts and time to look at this important question about restoring predictability and certainty to the Clean Water Act permitting process. The United States has several advantages when it comes to attracting capital for investments needed to grow and sustain our economy. We have deep capital markets, a global leading workforce in terms of productivity and skills, a strong platform for innovation and technology development, a world-leading transportation infrastructure to get products to market quickly, and low-cost and reliable energy, though I must say even that may be in jeopardy now with recent policies that we saw bring our electric grid close to the edge of breaking this past winter. The point being is that all these advantages can be erased with regulatory policies that create delays and uncertainty for capital-intensive projects. Let me just speak to the mining industry. Finding and developing our mineral resources in this country requires substantial investments, hundreds of millions and even billions of dollars. As a consequence, regulatory certainty is an essential and a highly valued commodity. Lengthy delays and regulatory do-overs in permitting decisions compromise the commercial viability of projects. They increase cost, reduce the net present value of projects, and impair potential financing sources. So the efficiency and predictability of the permitting process matters in decisions about where to invest. The choice can be stark: invest in countries with a predictable pathway for receiving permits within 2 or 3 years, or perhaps the United States, where it may take 3 or 5 times longer. Over the years, the process for obtaining Clean Water Act permits has become longer, more complicated, and more expensive. To make matters worse, we have now entered uncharted waters for regulatory uncertainty with EPA's claim that it can, 1, revoke a permit issued by another agency after the fact. The example the Chairman used in his opening statement, a project that met the test of a 10-year environmental review and obtained EPA's prior consent. Or instruct state and federal agencies not to consider any permit application until it decides whether development in that state is appropriate. Or change the process for reviewing permits after applications have been filed and pending for several years, and as a result effectively force companies to abandon their applications out of frustration. In short, it appears that in EPA's world it can never be too late or too soon to inject itself in the process or change the rules for reviewing project permit applications. Let me be clear. Valid concerns about environmental protection should be fully considered and addressed. At the same time, they should not serve as an excuse to trap projects in a limbo of duplicative, unpredictable, and endless review, or carry the prospect that decisions will be revisited when there's a change in leadership at an agency. There is a time and place for EPA to engage the permitting process and raise legitimate issues it does not believe are being evaluated. That opportunity arises between the time a permit application is filed and prior to a decision. Since the enactment of the Clean Water Act and until now, that opportunity has proven more than adequate to the task. Lawyers can debate whether the language of the Clean Water Act accommodates EPA's recent breathtaking claim of authority. But the fact that such authority was not apparent for 40 years should raise red flags as this subcommittee considers the questions before it today. Is this what the Clean Water Act intended? And is this good public policy? In the wake of EPA taking such extraordinary actions, the agency issues statements that it only plans to do so very rarely. But for all practical purposes, that is not a guarantee any project can take to the bank. Thank you very much for your attention today.
Thank you, Mr. Quinn. Mr. Ivanoff, welcome. The floor is yours.
Thank you very much. Chairman Gibbs, Representative Bishop, members of the subcommittee. My name is Nick Ivanoff, and I'm President and CEO of Alman & Whitney, an engineering company based out of New York. I'm here today on behalf of the American Road and Transportation Builders Association, where I currently serve as the Senior Vice Chairman. ARTBA, now in its 112th year of service, represents all sectors of the U.S. transportation construction industry, which sustains more than 3.3 million American jobs. ARTBA members must directly navigate the regulatory process to deliver transportation improvements, including obtaining Clean Water Act permits. The permitting process is essential for balancing the need for protecting our natural environment with the need to improve our transportation networks. ARTBA members benefit from a well-run permitting system because it lets them know their responsibilities up front and allows them to plan ahead during construction. However, in order for a permitting system to function properly, there must be certainty. Once a permit is issued, we need to be able to rely upon the fact that the permit's conditions will not change. EPA's decision to revoke Arch Coal's Clean Water Act permit in January of 2011 sets a very dangerous precedent which threatens to remove this certainty from the permitting process. Major transportation projects can take years, if not decades, to complete. In order for these projects to move forward, planners need to know permits received at the beginning of a multi-year construction process will be valid throughout the project's lifespan. While the EPA's decision was directed at a single mining operation, its impacts have been felt throughout multiple industries. As a result of EPA's actions, permit holders could be in danger of losing their permits through no fault of their own, but simply because EPA changes the rules in the middle of the game. Certainty in the permitting process is also integral to the financing of transportation projects. As you know, public-private partnerships are being eyed more and more frequently as a means of project delivery. In order for parties to invest in transportation improvements, they need some level of certainty. The prospect of a valid permit being rescinded at any time increases risk for project investors, making the project much less appealing or increasing the entity's required rate of return on their capital. EPA's permit veto is even more troubling in light of the agency's recent regulatory attempt to expand its jurisdiction under the Clean Water Act. If EPA's proposed jurisdictional rule is implemented, the universe of water bodies requiring federal permits will expand. This would be a one-two punch for transportation improvements, as their permitting burden would increase, and even if those permits are obtained, the length of their validity would certainly be in doubt. It should also be noted that there has been recent bipartisan progress in the area of streamlining the project review and approval process for transportation projects. If EPA's retroactive permit veto is allowed to stand, this progress, as well as any other benefit from future reforms, would be diluted. Any reduction in delay gained from improvements to the project delivery process could be negated by the increased uncertainty in the regulatory process for wetlands. ARTBA was pleased to see this committee introduce the Bipartisan Regulatory Certainty Act of 2014, which would curb EPA's ability to retroactively veto a valid permit. ARTBA supports this measure and sees it as a means to restore certainty to the permitting process. Mr. Chairman, Representative Bishop, ARTBA deeply appreciates the opportunity to take part in today's discussion, and I certainly look forward to answering any of your questions. Thank you very much.
Thank you. Ms. Pilconus, the floor is yours. Welcome.
Thank you. Chairman Gibbs, Ranking Member Bishop, and members of the subcommittee, thank you for inviting the Associated General Contractors of America to testify today. AGC represents over 25,000 construction contractors, material suppliers, and related firms. These firms construct buildings, highways, bridges, water and wastewater facilities, and other public and private infrastructure. My name is Leah Pilconus, and I am the Senior Environmental Advisor to AGC. On behalf of AGC, I maintain liaison with EPA and other federal agencies that interpret and enforce environmental laws. Construction activity in waters of the United States requires a 404 permit. AGC believes that EPA's authority to modify a Section 404 permit does not and should not extend beyond the point at which the Corps issues the permit. Unfortunately, EPA has taken a much more expansive view of its authority, asserting on its website that it can modify a Section 404 permit before a permit is applied for, while an application is pending, or after a permit has been issued. EPA's actions are disrupting the long-standing permit process that property owners and construction contractors rely on. The agency is disregarding the regulated community's reasonable, well-settled, and investment-backed expectations. It's taking away the finality of a duly issued permit. Under a joint EPA and Army Corps proposal to redefine waters of the United States, AGC expects many more construction projects to require Section 404 permits. If EPA has its way, every permit will forever remain subject to modification and even revocation at literally any time, simply because EPA unilaterally changes its opinion of information that it has long possessed. AGC believes it is now up to Congress to step in and solve the problem. The alternative is to allow EPA to render years of development planning and billions of dollars in investments virtually meaningless, based on nothing more than a reassertion of concerns that did not prevail in the original interagency review process. Working without a permit is not a viable option. The penalties for failing to obtain a necessary Clean Water Act permit can be severe, and that's just the tip of the iceberg. Many of today's infrastructure projects cost billions of dollars to construct, and they require huge sums of money up front just to begin work. Project delays and disruptions can easily cost millions and millions of dollars. Scarce resources are wasted, economic benefits are delayed, and workers lose their jobs. The widespread economic damage hits the property owner, the general contractor, the subcontractors, the material suppliers, the individual construction workers, and the community. What is more, those who are opposed to a construction project for whatever reason now have an incentive to bring citizen suits to try to compel EPA to modify or revoke the project's 404 permit. Legal proceedings mean delays wherein overhead and other costs continue to accumulate. If EPA is allowed to revisit the environmental impact of a 404 permitted project at any time, then the permit holder cannot rely on the sole statutory mechanism for measuring Clean Water Act compliance, the permit. Corps' regulations specifically address permit modification or suspension and lay out the 5 factors to be balanced in that inquiry. Those factors promote compliance and protect reliance interests. If EPA continues to assert unconstrained veto power over permits issued by the Corps, it will substantially deter investments in projects that require 404 authorization, which will translate directly into lost jobs and lost economic activity across the whole economy. Billions of dollars of investments are dependent on the finality that comes with a duly issued Corps permit. Leaving projects unbuilt has consequences far beyond the owner and users or who are deprived of the use of that project. Construction is a major contributor to employment, gross domestic product, and manufacturing. 404 projects generate significant indirect and induced benefits to affiliated industries. Reduced levels of investment in those projects translate directly into lost jobs and lost economic activity across the whole economy. The U.S. currently faces a significant backlog of overdue maintenance and its infrastructure system. Across its infrastructure system, the suspension, restriction, or lack of financial support for 404 projects could result in intolerable delays to the revocation and improvement of public infrastructure, including highway, transit, bridges, repairs, and dam repairs. Finally, the debt rating agencies will account for this risk through lowered bond ratings, particularly on controversial projects, resulting in increased underwriting fees and interest rates. In some cases, project proponents may not be able to obtain necessary financing or public funding.
Thank you, Mr. Falk. The floor is yours. Welcome.
Thank you, Mr. Chairman and members of the committee.
Put the microphone on and pull a little closer, maybe.
There we are.
Speak up like the previous witness did really good.
Absolutely. Absolutely. I want to thank you, Mr. Chairman, and your sense of humor, and the members of the committee for inviting me to speak to you this morning. At the outset, I want to note that I'm not appearing here on behalf of any client or any organization. I've responded to the committee's invitation as a concerned citizen, and I'm going to provide information based upon my experience and my observation. I am the Senior Director of Energy and Environment Initiative at the Law and Economics Center of George Mason University, where I develop and participate in forums designed to promote constructive dialogue regarding our nation's energy and environmental issues. I'm also a partner in the Washington, D.C. law firm of Hollingsworth, LLP. I've become familiar with the sources of the Environmental Protection Agency's alleged authority to veto permits issued under Section 404 of the Clean Water Act, as well as the disputes that have arisen recently regarding the extent of the authority both before and after permits have been issued by the Corps of Engineers, which is, of course, the primary authority responsible for such actions. Based upon my review of 3 situations that have arisen recently, I believe there's an urgent need for a comprehensive inquiry into whether the current statutory structure can be properly construed to authorize retrospective and prospective vetoes of legitimate business activities. The risk presented by such vetoes can be examined in these 3 situations that I've mentioned. The one, which has already been discussed at length, involving the Mingo Logan Coal Company, Spruce Mine Number 1. The second being the Pebble Mine project development in Alaska, which involves a prospective veto. And the third that I'm aware of is a request that was made in May 27, 2014, to the EPA by a group of Native Americans in Wisconsin who are seeking a prospective prohibition of exploration and extraction by mining companies, particularly the Gogebic Talconite mine, for protecting the water resources associated in those situations. If the congressional inquiry that I'm requesting this committee to recommend reveals that these risks exist, Congress should consider amending the Clean Air Act to preclude these problems. These amendments should require that the EPA's objections and withdrawal of specifications occur only during the normal permitting process, not before the permitting process is commenced and not after the process is concluded. Without these protections, these practices, which are enhanced by deferential judicial review, unreasonably expand the EPA's regulatory range and threaten to upset the delicate balance of powers and participation necessary to ensure the administration fairly of the Federal Clean Water Act. It's worth noting that with respect to the Mingo-Logan situation, that in the Supreme Court, an argument was made in the petition for certiorari that the Supreme Court has already decided the question under the Core Alaska case, which is cited in my materials, that the Corps of Engineers is entitled to full respect for its decisions and that they, in fact, have the authority to deal with these issues during the course of the permit issuing process. And that case can be found at 557 United States 261. It was decided in 2009. But aside from these legal arguments, there's a multitude of economic issues that should be addressed here. Given EPA the unconstrained authority to revoke section permits at any time strips the permits of the finality and regulatory certainty that Congress clearly intended for them to have. While the Corps is required to consider the impacts on investments as a part of its issuing process, It's interesting that the EPA claims it has no responsibility to consider these investment opportunities. Certainly, there is nothing in the Clean Water Act that suggests that they must do so, and therefore they have a situation that is left to their complete discretion without even considering or affording any deference whatsoever to these important issues. Permits are extremely important, and regulatory certainty is extremely important in all these situations, and the threat of deferential judicial review is also a problem. As we know from the recent decisions of the Supreme Court, all these issues are entitled to dispositive interpretations. EPA's interpretations are dispositive under the Chevron issues. They receive all sorts of recognition. Scientific issues are entitled to an extreme degree of deference. Under those circumstances, you can see that the danger of this situation, which deprives parties of opportunities to challenge these issues in the permitting process adequately, necessarily precludes any meaningful review of these issues by the courts.
Thank you. Mr. Parenteau, welcome. The floor is yours.
Thank you, Chairman Gibbs, Representative Bishop, members of the committee. I appreciate the opportunity to appear here today. I am, like Mr. Falk, appearing in my individual capacity as someone who has spent over 40 years dealing with the Clean Water Act, but I don't have a dog in this particular fight. I would note at the outset, however, I think it's very unfortunate there is not a member of the public from the Bristol Bay community here. The committee is debating a change in the law that could have very dramatic implications for the people that rely on a world-class fishery, a billion-dollar fishery that supports 14,000 jobs, that provides over half of the sockeye salmon that the world consumes. This is a one-of-a-kind resource, and it's in your hands. The fate of this resource is in the hands of this Congress. So with that, let me just say that EPA has interpreted its authority under Section 404C of the Clean Water Act in precisely the same way it's interpreting it today as it did in 1972, as the Congress did in 1972 when it wrote this law. This law authorizes EPA to exercise this very rare, last resort, very carefully crafted authority before, during, or after the issuance of a 404 permit. That was written into EPA's rules from the very beginning. I was a regional counsel at EPA. I'm very familiar with these rules. I applied these rules in the Attleboro Mall veto case under the Reagan administration, and it has been clear from the beginning that this authority has existed, and EPA has always interpreted it. It is also true that EPA has very, very rarely exercised this authority. In fact, obviously, it's very true that they very rarely exercise 404C veto authority at all, only 13 times out of, as Mr. Bishop said, 2 million permit activities. It's also true that EPA has been challenged each and every time it has exercised this authority in the courts, and it's true that EPA's position has been upheld by the court each and every time it's been challenged. Its administrative record, its science basis, its consideration of economic impacts, its consideration of alternatives, the reasons it gives for exercising this rare authority, every single facet of every single decision under 404C has been vigorously litigated by some of the finest litigators in the country, and each time EPA's position has been upheld all the way now to the Supreme Court. So in terms of law, it's well settled that EPA is well within its bounds in the way that it is operating under the 404C program. People can legitimately disagree, obviously, as to whether a particular veto ought to have been issued in a particular case, as to whether EPA should invoke the 404C authority at all. There are reasonable grounds and reasonable ways of seeing these things, but the authority to do that is clearly there. Let me also say, having been in the middle of this 404C process, it's multi-layered, it's 4 steps, it takes months, if not years, to complete. It's preceded by extensive consultations with the Corps of Engineers, with the project applicants, with local officials, with scientific authorities, with local communities, with site-specific investigations, with peer-reviewed science. All of that is part of these administrative records. It's all transparent. It's all there for anyone to see and anyone to challenge and anyone to debate. It's all on the record. It's all out in front. There's nothing in secret about it. Finally, I would like to say that the instances in which this authority has been used have produced some very, very positive results. From the small to the large. In the Attleboro Mall case, not only was the project in question a shopping mall built ultimately in an upland area that saved wetlands, but it led to a revolutionary change in the way that the agencies, the Corps and the EPA, administer the 404 program, and specifically the way that mitigation of wetland impacts are handled. It led to the most comprehensive set of mitigation regulations that we now have that have finally, once and for all, identified exactly and precisely how applicants can proceed to develop sites responsibly and with mitigation that actually works in accordance with the recommendations of the National Academy of Sciences and others. That all resulted from that one single veto. Before that point in time, there was no agreement on these agencies. Lots of arguments, lots of litigation, lots of uncertainty. The veto broke through that. The veto resulted in an agreement that finally resolved that. In the Two Forks case, very quickly, not only did we save Cheeseman Canyon, one of the most priceless trout fisheries in the western United States and very high value, not only did we save the 7 towns that would have been flooded had Cheeseman Canyon been dammed, but the Denver Water Board came up with a water conservation policy as a result of that and acknowledged that the 404C veto led them to do that, which allowed Denver to grow by 100,000 people with no further water supplies needed. 404C is not broken. It works. It's doing what Ed Muskie and the others thought it was supposed to do in 1972. It should be retained. Thank you.
Thank you. I'll start off here. First, I want to address what Mr. Parenteau just said. In your written testimony, you got the verbiage here for the rule, and then I have the actual Section 404C that's in the law, and I would respectfully argue that the law was loosely written. You cite the rule, not the actual law. And I think what we need to do is Congress needs to clarify this a little bit, because apparently for nearly 40 years the EPA didn't abuse this authority, even though it was not that clear, and now we've seen that. Now, to my question, starting with Mr. Falk, of the 13 vetoes that my ranking member addressed, would you concur that was operating within the law, and that's a separate issue than what's happened at Preble and Hampton at Spruce?
Yes, I would say so. And the reason I would say so is because the situation at those facilities is substantially more aggravated than most of those particular instances.
Yeah. Okay. I did want to make an announcement too that, for the record, both the EPA and the Army Corps denied our request to testify before the committee on this subject. So I want to make that clear. Regarding Mr. Quinn, on those 13 vetoes, would you concur too that those were operating within the scope of the Clean Water Act and their jurisdiction, and that is different than what they've done in those other 2 cases that I just mentioned?
Well, Mr. Chairman, I don't have all the facts of each veto. I would say that the veto we saw at Spruce was completely different and extraordinary. Several years after the fact, we had a 10-year review process. The project had been adjusted to address EPA concerns. EPA signed off on it. Here's what I find amazing is that I listened to the professor's testimony about how transparent the process is for the veto situation. But isn't that, the question is, and nobody seems to answer, is why isn't EPA engaging the process where it is directed to between the time the permit application has been filed and before a decision has been issued by the Corps? It seems remarkable to me that all of a sudden after the decision by the Corps, EPA finally has this remarkable revelation that, oops, we should have told them ahead of time this is not an area where we want.
So you would argue that the intent of the CWA was for the Corps and the EPA to be involved during the process, and they could veto during the process.
That's the context I see in the statute, and I concede that the courts have said that the language is broad enough to accommodate what they're doing. My point is that I don't think that's good public policy, and Congress ought to have a question whether that.
I want to take this so far, Mr. Quinn or Mr. Falk, on the expansion of the EPA's rule on the waters of the United States. it seems to me that there's a possibility there will be a lot more requests for Section 404 permits from all types of different entities, developers, farmers, local governments, townships, all of it. Did you see it that way, Mr. Falk? I guess I'll
Yes, I really do. I think we're seeing an effort by the EPA here with these proposals to basically bring in basically any place that connects in any way to waters under the United States jurisdiction to be extended. And we will see farmers, for example, who withdraw water. We will see other businesses that withdraw water that are from these things come into the regulatory process. We're going to see a surge of applications for these permits, and all of these people are going to have to rely upon what those permits say in the process of planning their business activities on a daily basis. And if it becomes uncertain, the question of how much they can invest, how big their businesses can grow, how intense their business activities can be.
I want to give Mr. Kovacs a chance to, I think you want to talk about that too, I think. Is your mic on?
I think the thing that troubles me the most is that in the process EPA was involved, it was actively involved, and in fact it wrote to the Corps and indicated that it might have some problems, but then it indicated just go forward. And then then the company starts construction, and then 4 years later they decide to exercise a veto. So I think that's an important issue. The second part that's really important is I think if you look at Justice Scalia's last discussion in the UART case 2 weeks ago on the greenhouse gases, he's very clear that Congress did two things. One is 40 years ago you delegated a lot of authority to the agencies, and much hasn't been done to look at that authority recently, and there's an institutional problem. But the second thing is he said, you know, different definitions can be looked at in different titles of an act, and what you have to do is look at the structure of the act. So when you're looking at this, in this particular case, the court looked at one word, wherever, and it didn't look at the entire structure of 404C and the role of the courts, or the role of the Corps and the role of the agency. So I think in that sense, and now you're going into waters of the U.S., another regulatory change, which is going to greatly increase the number of facilities that may be in this issue, or in this problem.
Thank you. My time's expired. I'll yield to Mr. Bishop.
Thank you, Mr. Chairman. Let me thank the witnesses for their testimony. I have to confess that I'm not entirely sure where to start here. But let me start with a couple of things that I heard. I heard a lot about this as being a dangerous precedent. I heard a lot about expanded jurisdiction. I heard a lot about alleged authority. Let me start with the authority. I'm going to read Section 404C. The administrator, by that they mean the EPA administrator, is authorized to prohibit the specification, including the withdrawal of a specification of any defined area as a disposal site, and he is authorized to deny or restrict the use of any defined area for specification, including the withdrawal of specification as a disposal site, whenever he determines. Now, I'm not a lawyer. Perhaps that's a good thing. I'm teasing. But that seems pretty clear to me. That seems pretty clear to me. Mr. Parenteau, would you agree that that's pretty clear authority?
Yes, and then more importantly, the D.C. Circuit agrees, and so apparently does the Supreme Court, which denied review in Mingo Logan. Let me read you what the D.C. Circuit said. Using the expansive conjunction whenever, the Congress made plain its intent to grant the administrator authority to prohibit, deny, restrict, withdraw a specification at any time, and the court emphasized any.
Okay. So hopefully that disposes of the issue of whether or not the authority being exercised is alleged or whether it is statutorily based. The second thing I would say is, so we seem to have a situation in which the authority that the EPA is exercising is well within its statutory authority and well within the way in which that authority has either been interpreted or validated by the courts. We also have a situation in which the numbers make the case unmistakably that the authority is rarely exercised. And so when I hear about uncertainty and I hear about not a guarantee, 0.99999% of the time, the 404C permit that is issued is validated or accepted or not challenged by the EPA. So I guess my question is, what's new here? There was a revocation of a permit under President Reagan. I don't think anyone's hair was on fire at the time. I don't know. I was doing something else at the time. One was denied by George W. Bush, H.W. Bush's EPA. I don't remember this being a huge issue that brought about a hearing of this type. So what's new? What is precedent-setting about what the Obama administration's EPA has done that was not precedent-setting by what the Reagan administration EPA did or the George H.W. Bush EPA administration? And I'll go further. This administration has vetoed or overruled an EPA veto of a 404 Section C permit. Why is that not precedent-setting? Why does that not yield the same kind of uncertainty that I keep hearing about? And I know I'm asking rhetorical questions, but I would invite any of the panel to help me understand what is precedent-setting about this, and why is it that if an agency over a 42-year history exercises its veto authority 0.00001% of the time, why does that induce the kind of uncertainty and the kind of sort of doomsday rhetoric about how people can't possibly plan when the EPA can drop the axe at any time?
I'd be happy to try to answer that, Mr. Bishop. I think it's a good thing that you're not a lawyer, because I think you bring some fresh perspectives to this. I've been involved in a lot of this litigation, but I'll admit I'm a recovering lawyer, so I'll try not to derail my recovery on this. But I think there are a couple distinctions. And as I've said before, I would agree with your statement that the courts have validated at least part of this interpretation, no question. And I'm not here to debate whether the language accommodates it or not. Apparently it does, at least on the retroactive aspect. But I think there are important factual distinctions, timing distinctions, on the spruce permit occurring with a very extended review period for a decade. Obviously, a lot of interaction between the agencies, a final decision, and then years after that final decision, a redo or revisiting on that. So I would, I think that is a clear difference. I think on the preemptive moves we're seeing now with are unprecedented, where EPA has gone into a situation and has basically said, we don't want any agencies entertaining any application it may receive until we finish doing our own study. And that has actually invited now new requests from outside groups to come and evaluate other areas as well.
May I just interrupt?
Please.
There were two preemptive denials pre the Obama administration, both by Republican administrations. How do those two preemptive denials differ?
Prior to an application being filed?
Yes, there were two of those prior.
I'd have to look and see what the context of that is.
But isn't that important? I mean, if what we're dealing with here is an agency's statutory ability to enforce the law that Congress has written and left in place, and one administration does it and it's a freebie, no problem, and another administration does it and we have a hearing with 6 witnesses and we're talking about expanded authority, isn't it important that we understand the distinction between those first two and what we're dealing with now? And I don't mean to put you on.
No, I think I don't know the context of that, so I can't directly answer that question. I think in this case we have a situation where a company's invested $700 million in looking to explore and develop a mineral resource, and even before it has the opportunity to file some engineering plans, specifics, and have it evaluated whether we can balance these different needs, it's being pushed out, and the state is being pushed out of any role in deciding what is really a balanced approach on this. Here's what I would say, Mr. Bishop, is that I think at the end of the day, the real question is, can't we accomplish what we're all looking for under the process that has been typically adhered to for 40 years, which is when an application is filed, this is when the interaction occurs, and before you reach a decision, if EPA wants to say this decision by the court is going to be wrong, I've talked to them ahead of time, and now I'm going to commence the proceedings.
And I guess that's my point. I accept what you say, and I guess my point is, how does one occurrence constitute atypical? I mean, there's been 60,000 permits applied for a year in the 5 years of the Obama administration, 300,000 permits and change. Once. How does that constitute something that now businesses cannot reasonably count on? In the 8 years, I'm sorry, am I over my time?
Yeah, you're over your time.
I'm way over my time.
Yeah, you're way over your time.
Thank you, Mr. Chairman. Okay, I will come back.
I was trying to allow the witnesses to respond to your
Thank you.
rhetorical questions, but just a comment that the bills we're looking at tomorrow in markup, I think, try to put a reasonable, rails in my bill, a reasonable time period for the 401c to come into effect, not 3 years later. So I think it's a common sense, reasonable time, and that's what we're trying to address in the legislation. Mr. Mark Wayne Mullins from Oklahoma, you have questions?
Yes, sir. That caught me a little off guard, though. It's a privilege and honor to be here and have the panel in front of us. And I have some deep concerns about it. I've dealt personally with the EPA. I've dealt personally on these permit issues. I have personally ran into hurdles when we're trying to build such things as retention ponds for drilling sites, when we're trying to do dirt work and control the runoff, where the EPA will come in and start making different permit issues, different requirements, and overrunning DEQ. And as Mr. Bishop was trying to allude to, he was simply saying, why now? Well, as a business owner, I can answer that and say, it's because it's politically motivated and we can't judge that. We can't simply stay up and say there's rules and common sense that applies to this. In 1972, Mr. Parenteau, is that how I'm saying that? Parenteau, I'm sorry. In 1972, the initiatives was to try cleaning up the waters because we were abusing it. The overreach now, the EPA, has become so absurd that I don't think anybody in this room can deny that there's some political motivation behind this. And that's where the uncertainty as a business owner comes in play. When you know what rules you have to apply by or play by, but then when no rhyme or reason can come in and say, no, we're just not going to do it, after we as business owners are investing millions of dollars to get a project done, and they don't even have to give us an explanation of why. There's a difference between 40 years ago and today. And I don't think even you, sir, can disagree with that. When we have a president that openly says that he's for something and completely against something else, there's a problem with that. And as an entrepreneur, what we simply want to do is say, let there be certainty in it. Tell us why. Where are you going with this? Not just because you feel a certain way. Where's the balance between the good of the people and your agenda? And I would like you, sir, to expand a little bit on where the difference, even in Congress, where we're at today versus 1972, and where the EPA has grown from 1972 to where it is today, and where's the certainty as a business owner, as a gentlelady said, because I'm not even going to try saying your last name, from AGC, the permitting process and the fines have become absurd. And how can we predict the future, and how can we adequately prepare for the cost of the infrastructure that this committee is all about?
One of the greatest uncertainties that we're dealing with has been given to us by the United States Supreme Court in two very controversial
I agree
decisions.
with that.
And if you're asking what can Congress do about it, what I would tell you is what the Supreme Court said you can do about it, which is to clarify the scope of the jurisdiction of the Clean Water Act. There's going to be tremendous disagreement about what the scope of that act ought to be. Let me just say this.
Well, the EPA came in and they made their own reach of what the U.S. waters are.
That's correct.
And they're moving way upstream, way above navigable waters. Now we don't even understand what navigable waters really means.
The proposal that's on the table would actually reduce the extent of the federal jurisdiction as it existed before these two decisions were handed down. The Fourth Circuit of the United States, one of the most...
Reduce?
Reduced.
They're moving farther upstream.
No, sir.
Sir, I will beg to differ on firsthand experience. because I had the farm where they had moved upstream, where they have denied us the ability to even fertilize our own ground because they're saying runoff is now part of navigable water.
Runoff is activities.
Activities considered a ditch? Say you got to be 1,000 foot away from a watershed, and a watershed is 1,000 foot of a ditch. When you live in northeast Oklahoma, everything's on a hill. You're within 1,000 foot of a waterway everywhere you go, if that's the interpretation.
EPA's rule has reduced the scope of the act with regard to ditches. It has.
I would like
as a matter of
for
fact.
you to clarify that
I'd be
and
happy
say
to do
how
so.
how that's even possible.
I would not only be happy to clarify it, I'll cite you the case that upheld a broader definition of ditches than EPA is using.
Okay, when they're coming back upstream, sir, and they're saying that now runoff is considered part of a navigable water. If a stream will flow into a navigable water, at least you should be able to put a canoe. When Congress specifically put in navigable waters in it, and now their interpretation is so much broader, farther upstream, and they're having a complete different interpretation of what U.S. waterways are, and you're saying they've shrunk?
Yes, they have. Before,
I don't think there's even anybody in this room that can possibly agree with you on that one.
I understand.
We just had a hearing on this about 3 weeks ago, and even they said they had broadened their reach.
Would you like some authority?
Gentleman's time's expired. Mr. Kirkpatrick.
Thank you, Mr. Chairman. I thank you and the ranking member for having this hearing, and thank all of our witnesses for being here today. And, you know, look, I mean, at the end of the day, everybody in this room wants clean water. We understand how vital that is, and being from Arizona, I know how important it is to life and to our future economic development. And so I understand the importance of this hearing, but I also represent a sprawling Arizona district that has coal mining, copper mining, 4 coal-fire electric plants, and you know, I understand the need for certainty in terms of the EPA regulations. And Mr. Quinn, I also understand math, and I want to congratulate you on these algebraic equations in your testimony. I like that, so thank you for that. But my first question is for you, Mr. Quinn. I mean, in the 40 years since 1972, can you describe for us what kind of changes you've seen in the regular EPA permitting process?
Well, I think the changes we would see would be as following: expanding the reach of what needs to be permitted over the years, more complexity in terms of obtaining those permits, more time to get them, and being more expensive to put forward the information that is being required now by EPA and the Corps of Engineers. I think the difference in 40 years in how the process has worked is, I know the ranking member and I have had this discussion on the context of various decisions, but I would say I don't think we've ever seen a veto of a pre-existing permit decision that has occurred so far after the actual contemporaneous issuance of the decision. On the previous or the preemptive type situations we've seen now recently in Alaska, I'm going to have to concede to the ranking member. I'm not familiar with all the facts, though I do believe that maybe the cases he is referring to might be areas where EPA had previously decided, or the Corps previously decided, were not appropriate for any filling. And then when a project proponent came back again, they just said, hey, we said no the first time, we're not going to say no. But I have to be careful about that. I have to look at all the context of those decisions. But I think the process has become longer, more complex, and I think that the regular rule of order had been, until recently, typically the issues that would be worked out within the context of once your application is filed and prior to final decision being made. And the veto was viewed as a veto of a pending or prospective or decision that's about to be made about an area that was within the application itself, not after the fact, not after reliance had been made on those decisions.
This question is for anyone on that panel who can answer it. Do you have any idea about the change in time for permitting and cost for permitting from 1972 till now? Anyone? Yes.
I believe that there are studies that shows that every year the overall permitting process takes longer, and that's just across the board. And if you went from 72 straight forward, I think you'll find several things. One is it's become much more costly to file a permit because you just have more to do. It not only is it costly, it's more complex. It's far more controversial. The use of citizen suits on virtually every project is just expected anymore. It's political, and then if you just look at the sheer number of regulations that have been imposed that a project has to comply with, it's increased since '76 about, my recollection is about 180,000 new regulations. So you put all that together, it's just tougher to move into a project, that's all. And so that when you get the permit, whatever's going to be decided should be decided within that time frame. And EPA actually had looked at this project within the time frame and passed, and then at a later date said, well, we've changed our mind. And I think that's the difficulty. If it was a month later and nothing had happened, maybe somebody would say, well, they missed it. But you need to put it in a box, and once the government approves that they can do the project, it should move forward, and then they use their enforcement authorities.
Mrs. Kirkpatrick, in terms of time, you were saying, we just recently completed a study for the Federal Highway Administration to look at the environmental process and the permitting process. In the 70s, it took about just a little over 2 years to complete the environmental process. It's closer over the last 7, 8 years, it's now closer to 5.5 years. So that gives you a context from 2 to about 5.5.
Thank you. I appreciate that. I'm going to yield back the balance of my time. Thank you.
Mr. Meadows.
Thank you, Mr. Chairman. Thank each of you for your testimony. So let me go a little bit further, Mr. Ivanoff. You said that the time to complete the environmental study has greatly expanded, according to your study. Is that correct?
Yes, sir, it is.
All right. So what regulations have changed within a law that got passed back in the 70s and now to make that process longer? Has there been additional regulations?
Well, I think part of the issue is there have been additional regulations, but there have also been interpretations. And if you take a look at interpretations by the Army Corps of Engineers, by EPA, certain definitions can be contradictory and confusing.
All right, so and that's where I thought you might go with it. So let's look at interpretations. The rule of law should give a consistent standard for everybody that is really, especially from an administrative standpoint, is not subject to individual interpretations. Would you agree with that?
Absolutely.
All right, so if we have this and we're making preemptive decisions on veto, whether it is under this administration or another administration, I could care less. What I want to make sure of is that those who invest in infrastructure, as you do, those who invest in building, as others here at the witness table do, those that invest in manufacturing, as others at the table do, have some consistent standard. Would you all agree that that's important, that we have a consistent standard?
Sure,
okay.
Absolutely.
Mr. Parenteau, wouldn't you agree that it's important to have a consistent standard?
Well, the saying is consistency can be the hobgoblin of small minds. It all depends on the facts of individual cases.
So yes or no, consistent standard or not? Would you agree with that?
Consistent application of statutory authority, yes.
All right. How many miles of road have you built, Mr. Parenteau?
Well, I did build a driveway of about a quarter of a mile.
Okay, so a driveway. I've built roads, and I've had permits from the Army Corps and EPA, a number of permits, and I've built miles of roads and built bridges, and that interpretation can be very troubling when there's not a standard. And the chilling effect that it has is I make a determination on whether I really want to make an investment or not, whether I want to risk millions of dollars based on perhaps a standard that Mr. Ivanoff that may depend on one bureaucrat having a bad hair day. That's not something that you would think would be good for us to do in terms of law, would you?
I'm not familiar that EPA has ever made such a decision.
Well, I know because you don't live in North Carolina and you didn't do the permits with me, and your only real knowledge might be a driveway that you've built. So, I mean, I'm telling you that we've built these. We get to see the inconsistencies. So let me put it maybe in a vernacular. You're an attorney, right?
Yes.
Do you think it would be a good thing for a judge before he hears the case to say I've already made the verdict? No. Yes or no? It's an easy question.
Of course not, and EPA isn't doing that.
I didn't say EPA was doing that. I said, would it be a good thing for a judge before they hear it?
No, they should hear the evidence.
Okay. how do we know, and let's say Pebble Mine, let's take Pebble, how do we know that the decision that the EPA has made, because you talked about transparency earlier.
They haven't made a decision yet.
Well, I understand, but their inaction has made a decision.
They've initiated a review, yes.
Yeah, and so they have made some kinds of decisions internally.
They responded to a petition from commercial and native fishermen, yes. They did.
Well, and the jury is out whether that was encouraged by some within the EPA. There's all kinds of rhetoric that's out there, and so that may or may not have happened.
No idea.
But is it important that we have a set of laws and a set of regulations where everybody can look at this transparently and say this was the decision that was made?
Yes, and we do.
Okay. With that, when you make a determination by some agency ahead of actually hearing the case and express their veto power, does that not give you some concern that too much power may be within one agency and one particular person?
If that were happening, it might concern me, but it's not happening.
Okay, so it's never happened?
Not to my knowledge, no.
All right, so you have intimate knowledge of some 2 million applications?
No,
I would not think
I have
so.
knowledge that 2 million activities went forward without a veto, but that's all I know.
So for you to not have a dog in this hunt as you started, how can you be so opinionated on all these particular issues to not have a dog in the hunt?
My opinion is based on my experience with the law and the way it's been applied. That's all I'm talking about.
All right. I'm out of time. I'll yield back, Mr. Chairman.
Ms. Edwards.
Thank you, Mr. Chairman, and I'd like to ask unanimous consent that a letter that I have from the caretakers of the land in Alaska and from the National Wildlife Federation be entered into the record.
So ordered.
Thank you, Mr. Chairman. Just in April, and I want to thank all the witnesses, too, because even when I don't agree with you, I don't think it's our job to harass you. I want to thank the witnesses today, and just a reminder that on April 9th, our full committee marked up H.R. 524, and that would have amended Section 404C of the Clean Water Act to limit the authority of the administrator of the EPA to veto the specification of the Army Corps of Engineers or by a state of a site for the discharge of dredged or filled material. When we held that hearing, I noted at the time that we hadn't held a single hearing or reviewed any legislation either by a subcommittee or a full committee on the issue, and yet we were marking up the bill. I pointed out that I thought that if this was such a serious concern, that we would have done that, and so I'm glad that we're holding this hearing today. I just want to note that Section 404C, under that section, actions can be taken if the impact of the permit activity is likely to result in significant degradation of municipal water supplies, including surface and groundwater, and significant loss or damage to the fishery, shell fishing, wildlife habitat, or recreation areas. And that's been true for this section, has been vitally important to the implementation of our clean water laws for 40 years. I just want to note as well that in my home state of Maryland, we have the 4th longest coastline in the continental United States, and the Chesapeake Bay, the largest estuary in the country, and several of its tributaries. And so we do have a dog in this fight. And the shoreline of our Chesapeake and its tidal tributaries actually stretch for over 2,000 miles with thousands of streams and rivers and acres of wetlands that provide freshwater flows into our bay. As we've heard the testimony and listening to supporters of the legislation, you would think that the EPA has actually exercised this veto authority frequently, and nothing could actually be further from the truth. As the witnesses know, and as my colleagues know, the Army Corps issues about 60,000 permits every year. And yet EPA has used this section of the Clean Water Act only 13 times, 60,000 permits a year, 13 times in the 41-year history of the law. And in 11 of those instances, that was done by a Republican administration. This administration, the Obama administration, the Obama EPA, has only exercised that veto authority once, count it, once, and yet we're holding a hearing to essentially prohibit the EPA from exercising that authority. It seems quite irresponsible in my view. I think the Act already represents a huge step forward by requiring states to set clean water standards and protect uses. And in my estimation, you know, it's important for the federal government to use its authority to do the right thing to protect human health and the environment. And so respecting the law, I would like to ask the professor here from Vermont Law School. You've studied the implementation of the Clean Water Act and the implications of this provision. Can you just please tell us for the record whether, you know, in permitting over 60,000 permits a year, it's even reasonable to say that there's been a gross abuse of the law and the implementation of the law, given that this veto authority has only been exercised 13 times, and again, 1 time under the Obama administration?
I don't believe there's ever been a gross abuse of the law in any of the 13 exercises of 404C, and I think the courts have uniformly ruled that that's the case. So my opinion is basically based on my reading of the way the courts have reviewed the use of that authority. And since EPA has been consistently upheld every single time, my only conclusion can be there's been no abuse of the law.
Great. Thank you very much. And with that, I yield.
Mr. Davis.
Thank you, Mr. Chairman, and thank you to the panel. This issue, it concerns me, and it should concern the constituents that I represent in central Illinois. There's been a lot of talk about the past, about previous administrations using authority to change Section 404 permits. But the one instance that concerns me is the retroactive use of the veto power. And that's with the mine in West Virginia. Now, I'm here in Congress because 22 years ago, I saw that a signature on a piece of paper here in Washington could have a detrimental impact on the largest employer that we had in my home county, in Christian County, Illinois. Our largest employer used to be Peabody Mine Number 10. Many of my friends, their families relied upon that coal mine that provided coal dug out underground in Christian County, in Kincaid, Illinois, in Pawnee, Illinois. It was put on a conveyor belt and shipped over the highway to the then ComEd coal-fired power plant that ironically shipped and still ships power up to the Chicago metro area. Now, because of amendments to the Clean Air Act, that coal mine was shut down because it became more effective, cost-effective overnight to bring coal in by rail from out west, in Wyoming and others, the Powder River Basin, by train to burn at the coal-fired power plant across the street from Peabody Mine Number 10. It was a devastating blow to our economy. Families lost jobs. And this is what scares me about the bureaucracy, because it's not just about legislation and amendments to the Clean Air Act that were signed into law back in the early 90s. This is about a federal agency taking a retroactive approach to a permit that's already been issued, to possible job creation in West Virginia, and West Virginia could be anywhere. That's what scares me about this administration's ability to talk about what's been done in the past, but drastically do something different in the instance that they use this same authority. Now, as a former congressional staffer, I've worked with the Corps of Engineers and the 404 permitting process in the past, and it is a long and arduous process. And it frustrates me that my colleagues believe that those who enter into the 404 permitting process always have nefarious reasons to want to get out and not follow any of the rules. I don't think that's the case at all. I think most who want to follow the rules and go through the 404 permit process only want to do everything that they're being asked to do by the different agencies who have jurisdiction. And to assume otherwise, I think, is something that goes against the American dream and what people want to do to create opportunities and jobs and grow our economy, which we all say we want to do. Now, I also understand I don't have a lot of time left, and I want to hear from at least some of you on some concerns. And I'm going to start with Ms. Pilconus. I enjoyed your testimony, and can you elaborate further on what you're hearing, though, from your members? Construction projects are key now, since we don't have as many coal mining jobs in Illinois. A lot of our former coal miners rely upon working on road projects that many of your members actually go out, put the risk, they risk their capital, they risk sometimes their savings, their life savings, to go create jobs for others in my district. And I want to know, have you all at AGC done any analysis as to how EPA and their regs support or stifle your business and economic output?
Sure, I'd be happy to comment on that. Speaking directly to some of our construction members, they have really great concerns about how this process has the potential to delay or stop construction. They've explained a lot to me about all of the millions and millions of dollars that go into a construction project up front before construction even begins. And so to the extent that you have delays, you have people who aren't working, you have all of the money that has been spent on lining up insurance, bonding, the investors who have put money forth towards the projects, the site designs, the contract documents. All of that money that has been spent is potentially kind of going for naught if the project cannot move forward. We've talked a lot about what is different now, and I think one of the things that is different now is we are kind of in the age of information technology. So many people, it'd be difficult to find a person who is involved in business who hasn't heard about what is going on with this permit that EPA has withdrawn years after. And so that is creating a lot of doubt, maybe more doubt than what investors would have had in the past. So our members are very, very concerned about the doubt that investors are going to have in putting money towards projects that are going to require 404 permits. They're also concerned about how many more projects may require 404 permits, and we're not just talking about huge in-stream channelization projects or massive amounts of fill material. We're even, per the definition of discharge of dredge material, talking about just mechanized earth-moving activity. And so it's really hard to find or to conceive any construction project in a sometimes wet area or in a ditch that is not going to require a 404 permit moving forward.
Well, thank you. That was a great response to my question, and it actually got to the crux of the issue, where many of your members are investing so much of their own money up front to go through the processes that the federal government, state government, local governments put forth, and they're doing that. And every time they have to go over another hurdle, it raises the cost of the project, which costs taxpayers in this country even more to move into construction, which creates the jobs all of us keep talking about. You are the ones, your members are the ones that create the jobs in this economy. It's not here in Washington. And thank you. And I think this process and the uncertainty that we give you and your members out here in Washington because of this regulatory environment, because of this administration, and especially with a retroactive decision on an already issued 404 permit is shameful. And I'm sorry that we actually have to have this discussion. And Mr. Chairman, thank you.
Mr. Rice.
Thank you, Mr. Chairman. I've said this before, but I think the United States is could be the most competitive country in the world, but we have a noose of regulation around our own necks, and we strangle our own selves and make ourselves not competitive. And I think what Mr. Davis was referring to earlier with the uncertainty created by this veto power just is one more thing that makes us less competitive. When it takes now 5 years instead of 2 years in 1972 to get one of these projects approved, makes us less competitive. That combined with our highest tax rate in the world and other regulatory burdens that companies have faced when they get here sends more and more jobs overseas every year. And what I want to do is fight that at every turn. I'm curious, what standard does the EPA, Mr. Parenteau, have to meet before they issue one of these
Unacceptable adverse impact to 5 specified resources: water supplies, fish and wildlife habitat, etc. So the statute has a very high standard to meet, unacceptable adverse impacts, and a very narrow set of special aquatic resources.
Mr. Quinn, do you think that's an objective standard? Is it easily measurable? Is it subject to discretion?
Well, I think standards like that are in the eye of the beholder. What's unacceptable? We'll start with that particular. It's become pretty subjective, and what one decision maker deems unacceptable could change with a different decision maker. That's part inherently in a lot of the process you have, and I think the discussion here today is, well, as subjective as that might be, when are you going to make that decision? Is it now? And when you make that, are you going to adhere to it or have somebody else come in later and say, I want to revisit that decision?
Yeah, I have personal experience with 404Q elevation letter that was issued by the EPA out of Atlanta. So to say this has only been done 3 times, maybe under 404B or C or whatever we're talking about here, maybe that's true. But here this was issued prospectively out of Atlanta before the environmental reports had even been completed, before any mitigation plan had ever been submitted. The EPA regional administrator sends a letter that says that I-73 will have an unacceptable impact on South Carolina. And absolutely has a chilling effect without the data in front of them. And the fact that any bureaucrat would have that power, I think, is shocking in this country. I think that if we're going to have any veto power, it needs to be made very, very objective and clear, and when it can be exercised. And I don't think we should have one at all. I think that's what Army Corps. That's what the Army Corps' job is to evaluate these things, and certainly shouldn't be done until all the facts are in. So, don't have any other questions other than to say I have seen this impact, and it has a huge chilling and anti-competitive effect. Thank you.
Mr. Massey.
I want to start out with a quick observation. All the successful business owners that I know, whether it's a mom and pop shop or big corporation or entrepreneurs just getting started, they have one thing in common. Although they might be ideologically opposed to the rules that they're playing under, all the successful ones are pragmatists. I mean, they look at the rules, they say, I understand, maybe I don't agree with these rules, but I'm going to play by these rules. But in return, all of the ones in my district, and again, this goes for a one-man shop or a big corporation, they ask certain things about these rules. Make sure they're understandable. Don't change the rules during the game while I'm playing the game. And make sure my competitors are playing by the same rules. And that's what's troubling about these recent revocations of permits, is that we're changing the rules during the game. We don't know that it's going to be applied uniformly to all the competitors. And how do you understand it at the end of the day? Ironically, a lot of these business people who may be ideologically opposed to these rules find at the end of the day that obtaining that permit provides an air of certainty and legitimacy to their endeavor that could actually, although pursuing the permit is hard and getting it, once it's obtained, it makes it easier to get the capital that they go seek. And let me make another observation about capital and investors. They're all uniformly risk averse. When I went out and sought investment for my own company, I knew it was too risky to go to a bank, so I went to the venture capitalists. And because I heard, they'll invest in risky things, private capital. What did I find out? They spent all of their time trying to reduce the risk, because that's the #1 attenuating factor on the valuation of your endeavor is the risk involved. And I think those observations that business owners make, Mr. Parenteau, you quoted Senator Muskie. I'd like to quote him too. In 1972, during the deliberations of the Clean Water Act, he said there were 3 essential elements of the Clean Water Act: uniformity, finality, and enforceability. Do you agree that finality is an important criteria?
Absolutely.
I do too, and that's what disturbs me about this. I don't think you should. People watching this discussion might say, well, if somebody's a bad actor or they violate the conditions of the permit, I understand it could be revoked. But that's not, it seems to me that's not what we're talking about here. It sounds like the EPA is asking to change the rules of the game after the game has started, if they decide to change their permitting methodology, or maybe they fail to do all their due diligence. They want more time after they've issued the permit. In fact, when Congress passed the Clean Water Act, they intended for expeditious decisions on Section 404 permits. Specifically, Congress instructed that to the maximum extent practicable, decisions on Section 404 permits will be made within 90 days. This seems to blow a hole, a loophole in that big enough to drive a truck through, that now the EPA has no onus to complete their due diligence in that 90-day window as Congress intended. And just quickly, and I want to ask a couple questions, but you said that the new definition of the waterways that are affected or under the jurisdiction of EPA won't change their jurisdiction or expand it. But twice in committee hearings, the EPA director or assistant director has testified to me it's going to be $100 to $200 million cost the economy to promulgate the new definition. So it's hard for me to see how it doesn't have a bigger authority. Mr. Kovacs, I had a question for you, a quick question. We've been talking about mining, and this in the context of a mining permit, but can you talk about other industries that are affected by 404 permits and how the recent treatment of 404 permits within the mining context could have ramifications in other industries and what those other industries are?
Well, certainly. I mean, the way it's structured right now, virtually anyone who moves dirt by a waterway would have that problem. And we might, mining may be controversial, but let's take a big box store, which can also be controversial to a community. But let's say, for example, you go in, you go through the entire permitting process, you have a wetland nearby, and you get a 404C permit, or a 404 permit. You start construction, and then 3 months later, EPA decides, well, maybe we don't like the runoff from the stormwater from the big box store. And maybe they came to that decision because the community decided they didn't want the big box store. All of a sudden, you've got the veto available. So they veto the permit 3 months in. And that's a, there was a mall case, and I think the professor worked on that 10 years ago or 20. But what happens is, all of a sudden, the permit is revoked. You have to ask, well, does construction have to stop? Well, yes. How can the company, plan to redo the permit? Well, they're going to have to do that during whatever time they have to deal with the bank. What happens to the financing? What happens to the workers that are on the site? And that's the problem. That's the single problem with the revocation after the permit has been finalized. And in this particular situation, EPA had all of the facts. And it decided to go forward with the permit, and it was 4 years later that it changed its mind. So when you talk about certainty, the certainty is when they review those documents, they're saying that this person or this permit complies with everything. And after that point when it's issued, they have administrative powers to take it back. They have civil fines up to $1 million. They can put the person in jail for a very, very long period of time. I think it's 15 years. During the process, if there's harm to the community, the citizens can sue. You've got emergency powers. You've got injunctive relief. What's so magic about just stopping the project? And I think that the question I think the Congressman Bishop asked, and that's a great question, is why is it different now? I think because there's so many things spinning around. There's more regulations. It's costly. It's taking more time. It's taking 5 years instead of 2 years. You've got citizen suits. You've got sue and settle. And when you put all of this together, when you go through this process, ask Cape Wind, 12 years of trying to get permits and lawsuits. If you've got the money, maybe you can make it, but the financing is going to walk away well before the permit's approved.
My time has expired, but just to complete that observation, it's not just mining that's going to be affected. It's
pipelines, big box stores,
home builders,
rail lines. I mean,
the point is delays cost money, right? Thank you, Ms. Kaplan.
Thank you, Mr. Chairman, and I appreciate the panel. And I wanted to ask a question to kind of set up the context for me, and I'll kind of go through the line here, starting with Mr. Kovacs. Although I realize you're representing a lot of different types of businesses, so maybe I'll start with Mr. Quinn. The average length of time that it takes companies in your business to obtain a 404 permit after they file an application. Do you have any idea what the average length of time is?
Well, a number of years ago, a lot of permitting was done under the general permit system because many of our operations have multiple other permits that look at very much the same thing: water, reclamation, and planning, and so forth. Over the years, the policy has been pushed to diminish the availability of the general permits that would take several months to obtain, and push more into the individual permits, which can take several years. So we've gone from several months to several years. I can tell you, for a large metal mine in this country, we're looking at 7 to 10 years to get all our permits together. So when the length of time is already diminishes the value or presents hard choices, when you put the uncertainty of now, you may go to a meeting with some credit or with some lenders, and they say it's going to take you that long. We say it's worth it because we have the certitude once this permit's issued in the United States, we live by it. In Indonesia, that may not be the case. Well, these decisions I'll make that guarantee.
So we're talking in excess probably of 5 years. Mr. Ivanoff, what about with you all in the Road and Transportation Building?
Well, as I mentioned earlier, maybe you were out, I mentioned to Mrs. Kirkpatrick that on average, we just did a study for Federal Highway Administration, and the entire environmental review process and approval process has gone from about just over 2 years back in the 70s to the last 5 to 8 years. We're over 5 years, so it's more than doubled.
Okay.
And part of it also depends on which jurisdiction of the Army Corps you get involved with as well, because of the different approvals related to wetland banking, for example, which is one of the mitigative techniques that we use.
And I would imagine, too, whatever Corps, for instance, our Corps and our Huntington Corps is very busy on the coal mine side, so there's a backlog. I know that to be true. What about Ms. Pilconus?
Yes, thank you. So the AGC Association represents all different facets of commercial construction. So our members are building everything from buildings, shopping centers, warehouses, and then the highways and other things that we've talked about here today. So what AGC contractors are telling me is that for a 404 permit, just talking about that permit specifically, generally anywhere between 18 and 24 months. For a general permit, a nationwide permit, 6 to 8 months.
Has that increased as well, like Mr. Ivanoff said, over the last several years, or is that pretty much steady through the 404?
It's increased over the last several years.
Okay, so we talked about the finality of the commitment of having a final recommendation, and I think that not only weighs into the financing aspect of it, but also the predictability of that community. And some of the things that I've been trying to bring forward, particularly in speaking with the EPA, is to try to get that consideration for the economic and job impact of the decisions that they're making. For instance, in the case of spruce, I mean, that was a huge blow to the economics of that area of the state. I represent West Virginia. In terms of your companies, Mr. Kovacs, at the Chamber, are you satisfied that this process really does include an economic and jobs review, or do you think it would be better served to either enlarge that or remove it, or what's your feelings on that?
Well, actually, I'm thrilled that you asked that question. Each one of the environmental statutes, starting in the when they were drafted in the 1970s, had a provision in there which requires a continuous evaluation of job loss and economic adverse economic impact. And EPA, we had FOIA'd this in the air area, and in the 40 years that they've had that requirement, they have never done one. And the same I would assume would be true of water, and I know they haven't done any in solid waste. So that's the first thing. But the second thing is, even in terms of regulatory impacts as to looking at jobs, which they do occasionally, EPA does only a regulatory impact on about 2% of its rules. So if you went back 15 years and you had 7,000 rules, you might have 146 that they look at something, and in only about, I think in only 2 did they do whole economy modeling. So they're really not looking at jobs at all, but more importantly, the continuous evaluation of the job impact is something very important, because when these regulations hit, they don't hit the whole country, they hit communities, and people have to really appreciate that.
You know, I would agree there, and I would contend, too, that maybe that's not what they base their decision on, but it has to be part of the bigger picture when you're looking at what direction you're going to go, and we found that to be lacking as well. And I thank you all for holding out and letting me be the last. I think I'm the last questioner. Thank you very much.
Mr. Jolly.
Thank you, Mr. Chairman.
Sorry,
youngest
Mr.
member
Jolly.
Let you go next. To the witnesses, thank you. Mr. Falk is a George Mason Law grad. Thank you for being here. I had a quick question for you. Is the prospective veto authority just zoning by another name?
I think it could become that as EPA is applying it, because in fact, what can happen here is they withdraw whole swaths of land and watersheds out of consideration for permitting activities, then you're basically precluding any sort of exploration, production, mining, extraction, or any other sort of useful activities taking place on that piece of land.
Do you think 404C should be changed?
I think it should. I think it should definitely be restricted to require the EPA in this extensive permitting process to make its objections known then, to say why now afterwards really presumes the fact that they didn't have an adequate opportunity to make their points known.
All right, Mr. Parenteau, do you think the law should be changed?
No.
Okay.
Congress created this situation. You understand this was a political compromise in 1972.
No, I understand, but
yeah, I mean, if you
heard a lot
want to
of
change it,
testimony
my
and-
recommendation would be give it to EPA. Give the whole authority to EPA. Put it where it belongs.
Okay. Mr. Kovacs, the President has been flying around the country taunting the Congress about passing infrastructure bills, which frankly we will do today, and very unceremoniously he's indicated he'll sign. Can you tell us a little bit about your project, no project study and the results of what decisions by the administration have done for jobs in the economy?
Certainly. The project, no project did several things. One is it asked a very simple question. In the middle of the recession, the Great Recession, we wanted to know how much investment was out there, the private investment that was going to go into projects that couldn't get permits. Very simple question. So we put it down, we localized it to the electric generation, and there were 351 projects in March of 2010 seeking to get a permit, and they were willing to invest $561 billion, which would have created about 1.9 million jobs per year for about 7 years during the construction period. And it was all hung up on permits. And about the same time when the Congress was doing the Recovery Act, there were questions around saying, well, we're going to fund the shovel-ready projects. And we were audacious enough to say there aren't any. If you've got a permit, you're building. And so we got a provision in the Recovery Act, Senator Brasso and believe it or not, Senator Boxer, they got a provision in which said that the agencies have to, for a Recovery Act project, they have to use the most expeditious way possible, which didn't look at all of these whenevers. It just said we're going to use the most expeditious way possible unless there's a major problem. And we didn't know how many it was going to affect, but out of the 214,000 projects that were funded during the Recovery Act, 192,000 of the projects were funded through the most expeditious way possible. Had they all had to go through an entire environmental review, you wouldn't have spent any of that money. So the entire permit process is broken. And where the administration is they keep on saying they want permit streamlining. We all want permit streamlining. But their version of permit streamlining has no deadlines. Our version of permit streamlining, or what we think of it as, is it has a lead agency. The lead agency coordinates all of the other agencies. All the other agencies have 90 days in which to say they're going to be in the project or out of the project, and then they make a decision on the project within 2 years as to whether it gets the permit. It doesn't change any substantive laws. It just says the agencies have a duty, and the duty is to review the permits and make a decision. And frankly, after that, the courts are going to take over if people want to sue.
Very good. Thank you, Ms. Pilconus. This type of delay, what does it mean for exposure of developers, construction companies, contractors, the financial exposure? And I'll ask you to be very quick. I have one more question.
Okay. Well,
Microphone, yeah.
Financial exposure has to do with all the money that they're putting in up front to get the project going. You know, whether you're talking about the owner of the project or the general contractor buying the property, getting the financing, the insurance, the
Surety, bonding.
Exposure with bonding is huge. You know, bonding is a guarantee that the project's going to be done. And if you cannot move forward with the project, the construction company is going to have to pay that money back.
And they bear the risk.
To the bonding agency.
The construction company bears
Absolutely.
the risk. Okay.
Yeah.
One last
It's
question.
different than insurance.
I apologize. Running out of time. One last question. Mr. Quinn, has Senator Muskie's intent been perverted by the EPA's use of retroactive vetoes? We've heard a lot about it today.
Yeah.
Would you consider Senator Muskie's intent to have been changed by the EPA?
I think the way it's been exercised lately is a departure from what was originally envisioned in terms of the time and process and coordination that was supposed to go on.
Do you think the law should be changed?
I think the law should be clarified, restore the certainty that it pre-existed. Yes, I think there's proper context and a proper process to get these decisions made properly, and people can rely on those decisions. And if they need to be revisited, they're revisited for legitimate reasons, not for temporal reasons that somebody else has taken over.
Sure. Thank you very much. Thank you to each of you.
At this time, I recognize Mr. Bishop for purpose of a unanimous consent request.
Ask unanimous consent to enter into the record the statement of Ranking Member Mr. Rahal.
So ordered.
Thank you, Mr.
This concludes our hearing. I want to thank our panelists again for coming in and testifying, and thank you very much.
It's quite a theater, isn't it? Nice to see you. Come back up and see us in Vermont.
I will. I'd love to do that.
Did you have a card?
Yes, I do.
Give me a card. We might just get in touch with you.
I would love
Sometimes
to.
we're just talking to ourselves. We need to hear some other views.
Love to come back up and sit by the river and enjoy all that.
Oh, yeah, the river's still in good shape.
Yeah.
We
Still
take
trout
good
in?
care of our river. Yeah, there's all kinds of trout. Rainbow
Good.
trout, brook trout, rainbow trout, trout.
That's good.
He stumps everyone.